There's rescission and there's reformation. Sure, many people are familiar with rescission. Rescission exists whereby there is an understanding that you entered into a contract, whether it's favorable or not. So in some cases, you might not want to rescind your signature because it creates a presumption that you did enter into it in the first instance. But then there's also another pillar called Reformation. Reformation, similar to rescission, affects an existing contract, but instead of annulling it or removing your signature to it or your agreement to any given contract, no matter how complex, no matter how simple, what Reformation does is it basically modifies it. A lot of people know of rescission, but are not aware of Reformation. This thing called Reformation, which is a tool in contract law, is what Protestants did with the Catholics around the 16th century. We hear Reformation when it comes to Christianity. That was a contractual dealing. That was a contractual performance between the people under the umbrella of the hegemony of Christianity, who decided, you know what? There's something that exists based on the living trust called testamentary trust, called the New and the Old Testament within the Bible, aka contracts, whereby we see our position when it comes to certain things, and we're not too interested in being under the terms and conditions that some people have made themselves up to be. Because whatever the terms and condition is literally what the parties become. So, well, they decided it's time for reformation of contract. And the medium to which that reformation of contract took place was they began calling themselves Protestants. Of course, there's a lot more involved, but in summary, the Reformation under Christianity of Protestants and Catholics and all that things in the 16th century is literally a contractual dealing. And that exists till today. So that goes to show, regardless of what the subject matter is, religion, personal, family matter, business, whatever it is, the principle of contract applies. The contractual principle of Reformation applies. Now, granted, just like every tool that exists under specific laws, there are standards, there are tests, there are elements. And to those standard tests and elements, there are different affirmative defense to each of them. Like when people speak about negligence, there are different types of negligence. When people speak about tort, there are different types of tort. There are different categories of each types. And there are different elements, standards, and tests to each types. But in this case of a note of contract and Reformation, what is Reformation? Reformation is a court's equitable power to modify a contract. In other words, you will have to bring a third party into the circumstance under equity jurisdiction. When people speak about exclusive equity, they'll show you the special thing about equity. It's far simpler than all that special exclusive stuff that they want to feed to you. It's very simple. It's basic stuff that people do every day, that you do every day, albeit you might not consciously realize it. But nonetheless, they just took these basic foundational principles to due process. Due process is that which ought to be performed, literally. And there are two types: substantial due process and procedural due process. That we've explained on Patreon page. So due process being what ought to be done based on certain hierarchies and based on the subject matter. Reformation is a type of due process in the realm of equity. In other words, an equitable relief. Equity is something that retroactively fits something that ought to have been done, hence due process. Reformation is a court's equitable power to modify. In other words, a modification of contract is reformation, rather than the annulment, which is rescission, under the presumption that the one enforcing said right has, in fact, entered into it in the first instance. So keep in mind, if your claim is that you did not enter into the agreement in the first place, then rescission or reformation are not the substance you ought to be entertaining. Things like misrepresentation, things like misappropriation, and things like unprivileged sharing of information are what you ought to be invoking. Many people know something is wrong, but how they go by doing it, they don't really care to know much for it. So long as they hear something, they just want to latch onto it and they want to defend it to the best that they can, just to validate that what they've latched onto without thinking much of it makes sense. Don't be that simple-minded. Think in simplicity, but most importantly, comprehend that in order for you to come to the simple conclusion, you must know the intricacies. So be competent. Reformation is a court's equitable power to modify a contract to reflect the party's true intent. Meaning predominantly there are people who already agreed to something, but somewhere along the line there was a minor error, and that created a huge discrepancy on how said contract is enforced. So a third party comes in and retroactively, aka equitably, aka due process, modifies said intent. Reformation is a court's equitable power to modify a contract to reflect the party's true intent, where some error has been committed. Courts require plaintiffs seeking to reform a contract to prove certain elements. Look at that. So now, do you know that elements of a contract? We go over that on Patreon. Most people don't know elements of a contract, but they're going about contract this, contract that. The Oregon Supreme Court in Jensen versus Miller summarizes the common law requirements for showing reformation, stating that parties, meaning all parties, seeking reformation must show, 1, these are the elements to this principle of contract called reformation, aka modification of contract. Court and satisfaction is not a modification of contract. Court and satisfaction is an element of the tone. Court and satisfaction is a type of settlement, not modification. Reformation under a contract law is modification of contract. The first element, according to the Supreme Court of Oregon, so now this is on a state of Oregon level. You might want to look into your state and it might slightly differ, but usually they'll be uniform. Common law. The first element is that there was an antecedent agreement to which the contract can be reformed, meaning, well, what are we reforming? What does it look like? Who entered into it? Meaning there has to be a valid existing substance that is the foundation being modified. Otherwise, the concept of reformation would not exist. So that's the basic. 2, being the second element, is that there was a mutual mistake, meaning all parties made a mistake. And sometimes, if both parties do not necessarily agree on what's being reformed, guess what shows that both parties did make a mutual mistake? The first element, which is the language of the contract that was signed into in the first instance. So now where there's a conflict in the second element, where one party says, no, that's what it is, and the other party says, no, that's not what it is, so we have to reform it. But then they're going back and forth, they don't agree. Well, what does the language of the contract itself says? Whatever it says on its face, because the language makes the law in the circumstance. And the parties who might be in dispute or who might unanimously agree that, yes, a reformation is to take place, did sign to it. Once that contract, which is the foundation of it, which is the subject matter, once it shows the succinct intent, then it can potentially override the second one. But for the most part, it's much easier where there's a mutual mistake. Again, the second element to reformation is that there was a mutual mistake, and both sides made the mistake. Both sides made the error. What shows that both sides made the error is that you both signed to what? The first element, which is that there was an antecedent agreement, a previous agreement. That's what antecedent is, to which the contract can be reformed. What shows evidence of mutuality? Signature to it, and the attestation of a third party to it, or the signature itself. What if one party says, well, that's not my signature, I didn't sign that? Well, then that demands and warrants that you, the one making the claim and the intent of reformation, know the rules of evidence when it comes to authenticity and admissibility of evidence. No matter where you go, you cannot run away from competence and how foundational rule of evidence works. So keep running away from rules and keep saying it's their stuff, right? And comprehend that it's yours. And it's just being adopted under a different name. Nonetheless, second element says that there was a mutual mistake or a unilateral mistake on the part of the party seeking the reformation and inequitable conduct on the part of the other party. So that means one party can disagree also, because, well, they're a party to the contract, and either one has the ability to reform it, to modify it, to change it, so long as that which is being reformed is then inequitable. What is being reformed is the language, and the language is what compels performance, aka conduct. So if the language is inequitable, then obviously it's a fruit of a poisonous tree that creates a poisonous or inequitable conduct. So now one party or both are modifying the contract. The third element, which is an inclusion, meaning and, is that the party seeking reformation, both or one, was not guilty of gross negligence. In other words, good faith. So now when you speak of gross negligence, you're looking automatically at tort, because negligence is a type of tort. And gross negligence is one of the type of negligence. Is it intentional tort or not? It's an entire different subject matter. But in summary, the contract must exist. You must have evidence of it, that the other party involved, that you're bringing in or calling into action for reformation, you have to show the evidence that the contract itself exists based on rules of evidence. And two, both of you or one of you, or if it's more than two parties, a few of you, even if it's 1% of the totality of parties, can actually modify the contract, so long as, which is the third element, as there's good faith. It goes on to give example. For example, in Central Oregon Independent Health Service Inc. versus State, an Oregon Court of Appeal, which is basically the Supreme Court of the Supreme Court, or the overview or oversight of the Supreme Court, whether on a state level or federal level, in this case on a state level, the state of Oregon, which popularly dealt with this circumstance. An Oregon Court of Appeal held that a plaintiff stated a claim for reformation, which is a principle based on these three elements. So when you see this term reformation, when it comes to contract law, it basically talks about the foundational contract that's valid, and it can be shown to be valid, and the intent to modify it based on good faith. It's that simple. That's what reformation is in summary. An example is that an Oregon Court of Appeal held that plaintiffs stated a claim for reformation by stating that previous contracts required parties to, quote, pay at the correctly calculated rates, as opposed to the current contract, which had been construed, quote, to impose no obligation on parties to correct erroneous rates. In other words, if an intended act is linked to two separate contracts, one of them can annul the other. And because of that, you can reform or modify the more recent one, because something pre-existed it. Another example in the everyday man circumstance that claim rights is, well, someone created some statute that violates a constitutional secured right. Well, there was a predominant contract that exists called the Constitution. Hence, notice the constitutional challenge. Hence, being able to speak up through different means of affirmative defense. Laws are contracts. Yeah, sure, the contract makes the law, but laws themselves are contracts. In this instance, they give a private thing whereby some entities say, well, this is how you pay us, and well, there's no liability on our end. And then something else was created at the end that says, well, there will be liabilities based on how you pay us. And then someone says, no, let's reform this because the previous one said, no, there'll be no liabilities on this rate. So it overrides based on principles of subrogation, seniority, and the predominant effect that the more recent one did not annul the old one. Well, instead of it being private contract based on who gets paid and at what rate, your foundational principle is the Constitution, because all these rules and laws does not and cannot annul the constitutional foundational principles. Thus, you can always reform a code. You can always reform a statute. The signatory to these state and federal public laws, public act, session laws, congressional act that are statutized and put into codes and policies. In some very few cases, they're put into policies. All these public laws, public act, the signatory to it are the Congress members. So they can receive their signature. But the issue is most people don't know that based on the right to petition, redress, and grievance, they can also be signatories to these public act and public laws. People are not even on that level. People are so lost with their own little box of what they're stuck in, and their need to just ramble on about irrelevant trash rather than dealing with the substance of society and real life. So when it comes to laws and society at large, you can rescind your signature if you first invoked your right. If you first invoked your right to petition, redress, and grievance. Most people don't even know they can do that in the first place when it comes to creation of law. So let's put that to the side. But Reformation, on the other hand, is what you do when a constitutional challenge is done. Reformation, on the other hand, is what you will always do whenever there's a supposition of claim against you, or in any other circumstance in other private contracts. And guess what? They do this on the other hand also against you in many ways. You hear people talk about, oh, they're trying to recontract with you. Well, what they're speaking of is Reformation. Does it meet 3 elements of Reformation? If it doesn't, then it's not recontract. It is just a cloud. A cloud of legality or a cloud or fakery that something exists is definitely different from Reformation. If they're sending you some letter about one thing or the other, but they're not meeting these 3 elements, then it's not Reformation. It has nothing to do with contract. It's just some other BS they're doing somewhere that is completely invalid. On the Patreon page, we'll go over the details of how to enforce the injunction based on the principles of the contract. Most people say they do the injunction. What if it's violated? How do you enforce it? How do you prove that the parties that you send those injunctions to are liable? Okay, well, you say you sent it to the sheriff. Okay, cool. And the reason you said you sent it to the sheriff is because the sheriff is the original police in power, and he delegates his authority to the local municipal police. Okay, well, prove that. Prove that the sheriff himself has the ability to prevent you from being arrested in the system of all these other municipalities who are their own home rule unit. Prove that. You would have to know the intricacies of contract law for you to be able to start talking all the trash. If you put in an injunction and someone violates it as a way to try to test you, how do you enforce that injunction? Do you know it? Don't just start sending in documents that you get from people that you get from third parties, or a follower who follows the follower, or who hears something without knowing how to enforce it beforehand. Because if you run at the last minute, you might not very well get where you need. Till next time, take care. Best of luck. Beautiful people, I'm inviting you to join my Patreon page. The things we speak of over there are basically synonymous with webinars, each videos, when it comes to the quality of information and the actual aspect of it compared to the one here on YouTube. We speak about residual income and how to sue people, make residual income if you're willing to do that. We speak about tort and garnishment, remove the speculations of maritime lien. We speak about banking, express trust, all the intricacies that are important. We speak about trust-related matters, different types of trust, how to actually function in commerce. We speak about the intricacies of how to actually do the W-8 ban and what makes it foreign, what tax treaties are, the stuff people won't tell you about. We speak about things of spiritual nature. We speak of child support, the intricacies of it, how it's all property right, and how cloud of legality is brought to life. Exactly how they do it and how you tackle that beyond speculation. We speak about how laws are made and how it's applicable or not, the intricacies according to the Constitution. We speak about the truth of what most people are fearful and speculative about. We go over the elements of the things that people need to know when they make claims to sue people to make money, either criminally or civil. When it comes to substantive right, we speak about the venue and the playing field that a lot of people don't know that they're stepping into. If you don't know the venue and the playing field you're stepping into, you're in for a world of hurt. We clarify misconceptions. We speak about the intricacies of things we speak here on YouTube, but more in details on Patreon. Basically, stuff that our YouTube are synonymous with things that are for the birds. One of the Patreon are the premium quality things. In the past, we went over IRS manuals in different ways when it comes to the Express Trust 98 number. We went over the intricacies of mortgage, land, title. We went over issues with things like driver's license and the treaties that are the solutions for it based on examples of my own first-hand knowledge and experience. Speaking about trust-related matters, more on child-related issues. We discuss other aspects of things. We discuss how to really come in as a natural person and the fact that there are actually tools that pre-exist that are meant to be used. A lot of people say, well, don't use this, don't use that. Well, do you know that same thing you're running away from is actually the solution? And do you know that's one of the ways and your first step to actually garnish it? We speak about the intricate details of discharge. We speak about things of reality that goes over people's heads. More on discharge, we speak about the functionality of spirituality and cosmology and astrology and how you can actually put it to use. We speak of the what, why, and how and the importance of a foreign trustee and the resident status. We speak about spiritual things when it comes to plant, the functional aspect of it. We speak of the language of the difference in the truth of legislative fact compared to adjudicated fact and what it really means when it comes to judicial notice. We speak about the lunar mansions, how to put them to use. We speak about tort, U.S. Marshal Service. We upload documents and treaties, original certified copies. Tax evasion. We show the IRS manual that shows the difference between tax evasion and tax avoidance. We go more in about how to actually make your own pocket bigger in commerce. We show the videos and experience that I have when it comes to discharge and the explanation of it. We show elements and details. We speak of the things relating to holding people liable. Speak about the different intricacies of how these entities are used against you and how you ought to use it and to know the playing field. A lot more that a lot of people are seeking but will not find. Again, each of these videos are synonymous to webinars of their own. We speak about how to get rid of statute of limitation. Most people's remedies, they say, are barred by statute of limitation, but there's a way out to that. We speak about how child supports are private and how and why they want to charge you thousands of dollars for some transcript, how to nip that in the butt, and a different aspect of it in great details and in great increments. Speak about the intricacies of fraud, how to prove it, the different types and the elements to it. Speak about tort. Speak about speak about trust. Speak about the subtleties of invoking equity and how to structure your document, and so on and so forth. Speak about private right, the incorporation doctrine, how people use UCC 1-103207-308, how that really doesn't actually preserve your right, contrary to the speculation that a lot of people throw around, and that your solution is actually in plain sight, beyond the volatile and immutable UCC, which, by the way, the UCCs are also copyrighted. We speak about spiritual things in nature, of how to use flame, and the functional aspect of beyond make-believe. I show my own first-hand experience in Chancery Court, and so on and so forth, and a lot more to come. Till next time, take care. Best of luck.